There are three issues that I would flag with regard to the 2019 amendment, and some of the speakers have flagged some of the issues in the previous session. The first issue that I would like to flag is that it has brought in certain new concepts, certain best international practices, like the attempt to incorporate the issue with regard to confidentiality. Arbitration is essentially a private methodology of resolving disputes. Whether the proceedings are to be confidential or not was not clarified in the statute. But now it's been stated explicitly that the proceedings shall be confidential, except when it comes to enforcement and implementation of the award. This is something which is very good to my mind, and it incorporates the best international practice. But really the ecosystem and the mindset has to change. For that, if you, I think, visit any of the arbitral centers, you will find that they display the cause list with the names of the parties on their websites. So that has to change if you have to really give effect to this sort of a provision. There is also the timeline issue which was flagged in the previous session, which I think is very important, especially for the international commercial arbitration, where it says that an endeavor shall be made to conclude the arbitration proceedings within 12 months, rather than a very strict timeline, because the arbitral institutes have their own methodologies of controlling the timeline. That is also very important. Second is, and as you would have seen by now, that there are certain very ambitious amendments which have been sought to be incorporated in the Act, like the Arbitration Council of India, where it provides for grading of the institutions. That is something which I think is quite unique to this Act. And grading may help, may not help, that only time will tell. But it's a step which is required if we are going for multi-arbitral tribunals and multi-arbitral organizations rather than a single arbitral organization. So I think grading will definitely help in the long term, but how that organization is structured is very important, because the private sector must have confidence in that grading institute, as it were. We have seen the grading institutes which are run with regard to the credit ratings, and some of them are not doing too well. Suddenly the bond from AAA changes to CCC overnight. So the grading institute must inspire confidence, and that can only happen if people from the private sector who are reputed are involved in this entire exercise. There is also the 8th schedule which provides for qualification of the arbitrators, and let us see how that proceeds when it is notified. As of now, only 11 out of 16 sections have been notified, which form a part of the amendments. The 2019 Act has also been off to a rocky start, as you know, which was previously mentioned. The Supreme Court has already struck down Section 87, which provided for automatic stay of the arbitral tribunal's award. And the position which was prevalent under the 2015 Act has been restored. The third issue about the this Arbitration Act amendment is that there are certain gaps which have not been addressed. For instance, the role of the experts. And I think that's a very vital issue, especially like you were discussing the construction arbitrations in the previous session. What is the role of an expert? What credence will be attached to that expert? How do you develop expert witnesses in India? And that, to my mind, is a very important issue. We don't have a pool of expert witnesses in India. For instance, I was told that in 2019, GAR has notified about 236 arbitration expert witnesses from 22 jurisdictions. Surprising part is no one is from India. So this is one area which really needs to be addressed, and I wish under this Act they had incorporated some soft law with regard to how the evidence of the expert witness would be tendered, to what extent it would be believed. For instance, in a construction contract, what is most important is, what was the tipping point? What was the point which led to the delay? There may be delay in getting approvals, but those delays may not hinder the project in itself. So these are very important. This is a very important issue about the role of the expert witnesses. And I wish that was also addressed in this Arbitration Act. As far as the scope is concerned, as a judge, I feel that the recent trend has been to read down the concept of public policy. Is no longer a bull in a china shop, and the various judgments have read it down, and everyone is emphasizing that the arbitration is an alternative dispute resolution mechanism which should be allowed to work on its own. But recently, a very interesting judgment from the Supreme Court has come. That's, I'm told, a topic of discussion in another session. The Sasan judgment, which says that the minority award, which followed the clause in the price escalation clause, as it were, in the contract, that has been affirmed by the Supreme Court exercising power under Article 142. That is something very unique. What I had heard was that in France, an award, even if it is set aside, still has life. It can be implemented. For the first time I have seen that a minority award has been affirmed by the Supreme Court and made into a rule of the court. So these are some interesting developments which are taking place. And it's an evolving situation. We are an emerging jurisdiction, but we must take the right step forward. We should not be going in the wrong direction. And the real emphasis is to give a push to the arbitration sector, as it were, because I can tell you as a judge, the system is rather overloaded as if it were now. And we really need to give a push to the alternative dispute resolution mechanism, because these are certain disputes which cannot wait for a resolution. You cannot get money after 20 years or 15 years, because by that time that organization itself may not survive. So these are issues which need to be flagged, which need to be discussed, and I am sure with the assistance of the co-panelists, we will arrive at some conclusion. So may I request Ms. Darshini Prasad to talk about confidentiality in arbitration.
I've got a slide here which is not necessarily one that accompanies my entire presentation, but I thought it would be helpful to just have the Act, the relevant provision flashed up for you as we talk through the provision today. So, there is a saying that the road to hell is paved with good intentions. And unfortunately, I think this particular provision doesn't fall very far from that. Why do I say that? I'm going to probably go through 3 different questions through the course of my presentation, which I'll try to keep quite brief because I know we're already over time. But 3 questions to maybe talk through the context to the provision and then the specifics of the provision itself. So first I'm going to address the more threshold question of, is it even right to make confidentiality a default provision? And having heard Justice Manmohan's introduction, I feel like that's now going to be a slightly controversial question to be asking, but hopefully the conclusion is not going to be controversial. The second question I'm going to address is, assuming you do want to make it a default provision, was it appropriate to do that statutorily, or should it have been left to the development of the common law? And the third question is, now that we do have a provision in section 42, 42A, which you can see in front of you, now that we do have a provision, how does that provision measure up as regards the task it was intended to fulfill? So turning to the first question, as some of you might know, and for those of you who don't, the genesis of the section 42A and most of the amendments in 2019 came from a 2017 high-level committee report that was commissioned by the government of India. The high-level committee starts on the premise, it's a rather brief discussion on confidentiality, and understandably so. They had a very wide mandate, and this was probably one that got a little bit less attention. But the discussion on confidentiality in the high-level committee report starts on the premise that confidentiality should be the default provision. When I first read the introduction, it says quite encouragingly there are divergent views on confidentiality, and I thought that might mean we'll talk about the other end of the spectrum where there are proponents of transparency over confidentiality. But the report itself confined itself to just outlining the position of Hong Kong, Singapore, and India, all of which are jurisdictions that do recognize a duty of confidentiality. So why do I talk about this? The debate today about confidentiality is now slightly more complex, and that is partly because of growing concerns for transparency, which is what I alluded to earlier. One might argue that those concerns of transparency primarily arise in the context of investment arbitration, where, for instance, you have states involved, and the issues in dispute often implicate acts of sovereignty, acts of public interest. So it's understandable why there would be transparency there. And of course, that's different from commercial arbitrations. But I'd like to pause just briefly to question that assumption, especially in a country like India, where we know that state-owned entities, public sector undertakings are one of the largest categories of litigants that you have. Is it really that easy to draw a categorical distinction between commercial arbitration as one that implicates private rights and investment treaty arbitration as one that implicates matters of public interest? So just a point to note there, is it really a clear distinction? But even if one were to put aside the issue of investment arbitration, just looking at commercial arbitration, there are increasing calls within the commercial arbitration space, including from jurisdictions like England, which have historically recognized confidentiality, for there to be greater transparency. And critics of confidentiality, I don't want to call them critics because it's not that they categorically reject it, but those who call for greater transparency point to what they call the costs of confidentiality, and that are decreased accountability for decision makers when their decisions aren't available for public scrutiny, concerns over less predictable decision making because there's no scrutiny again, concerns over stifling of the development of the common law, or more generally just the growth of a body of precedent over commercial disputes. In fact, in the past 5 to 10 years, there has been a greater shift towards transparency already. You see arbitral institutions calling for publications of awards, albeit anonymized. You have databases to gather information on arbitrators now. I say all of this, I am a proponent of confidentiality myself. I say all of this merely to point out that maybe there was a debate that could have been had by quite a diverse range of stakeholders on this question of confidentiality. But that's now maybe a bit of a missed opportunity, although I still hope that by the time we get to the end of my presentation, there is some scope to revisit this provision, and so maybe that's a debate that can be had then. So moving on to the second point that I wanted to talk about, which is assuming you do want to have a confidentiality provision, should it necessarily have been statutorily codified? Now this is the divergent views that the high-level committee did talk about in its report. Hong Kong has a statutorily codified provision. England and Singapore do not. In fact, in 1996, when the Department Advisory Committee for Arbitration was considering the 1996 English Arbitration Act, there was quite a deliberate decision not to codify confidentiality because, in the words of the report, there are a myriad of exceptions, and it would have been impossible to try to identify each of these exceptions, and it would have been preferable to have the law develop on a pragmatic case-by-case approach. And that is in fact what still happens in England and to a certain extent in Singapore as well. You fast forward 20 years to where we are today, the law on confidentiality and the exception still is not settled, even in England. It's unclear whether the fact of the arbitration is itself confidential. It's unclear, quite controversially, whether you can disclose information to affiliates of a party to an arbitration, to a parent company, or whether even that might be stymied by confidentiality obligations. And it's also unclear whether witnesses are bound by duties of confidentiality, and if so, what the doctrinal basis for that would be. Now, again, this was a policy decision taken in '96 in England and subsequently in Singapore as well. I personally think, and again, this is a point for debate, I personally think that in the Indian context, it makes sense to statutorily codify it for a number of reasons, including what Justice Manmohan alluded to with the backlog of cases. It's better to try to reduce the number of issues that need to go to the court rather than try to exacerbate them. So perhaps in this specific context, it was good to statutorily codify it. As I understand it, over the number of decades that arbitration has been prevalent in India, the matter of whether or not confidentiality is a duty still hasn't percolated up to the Supreme Court or even the High Courts, I believe. So for those reasons, I personally think that it should have been codified. But as will become apparent when we look at the actual text, the issue of the scope of exceptions is perhaps one that the judges will need to be bothered by even moving forward, notwithstanding a provision to that effect now. And so I hope I'm good on time, Justice. But moving on to the third and perhaps the point that all of you were hoping I'd address first, which is the actual provision in Section 42A. You have that up on the screen there. I've contrasted it with what the high-level committee had recommended because it is quite an interesting comparison. And you've got the high-level committee, and it's up for you, but I'll read it quickly, which suggested that there be a new provision providing for confidentiality. Well, I said uncles, but that means unless. Unless disclosure is required by legal duty to protect or enforce a legal right or to challenge or enforce an award. Fast forward from 2017 to 2019, you have a Section 42A, which starts off with notwithstanding anything contained in any other law for the time being in force, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings except the award for purposes of enforcement. So there are three components to Section 42A, which I'm going to talk about. The first is the introductory language, which is as I understand this, described as a non-obstante clause. The second part of it talks about the persons to whom the obligation applies, three specific categories. And then the third is the exception. And unfortunately, all three of these are problematic. Starting off with the non-obstante clause, effectively what it amounts to is to give confidentiality in arbitration almost an overriding supremacy to all other laws that exist in India at this point in time, which would require disclosure of facts. The most obvious example would be listed companies that need to make disclosures, mandatory disclosures, under the Securities and Exchange Board Act, or applications for right to information under the RTI Act. How do you deal with these? One could argue on a plain reading that now this obligation of confidentiality will gain supremacy over those. I'm sure there will be creative arguments that come to say otherwise, but at least on the face of it, that is what it suggests. More interesting, perhaps as a practitioner from outside of India, the concern I see is what do I do if I have a client who's a foreign listed company that has a subsidiary involved in a dispute here or is involved in an international arbitration seated in India? How do they deal and comply with their foreign listing obligations if they now have a mandatory duty of confidentiality under Indian law? So that is the non-obstante clause. Very quickly, the other effect it does have, which I didn't mention, is that if you'll recall, the high-level committee suggested that unless the parties otherwise agree, the confidentiality duty would apply. But given the clause and the way the provision is drafted, it's arguable that there's even no scope for party autonomy now, so parties will not be able to contract out of it, which is obviously also problematic. The second issue is the scope of persons subject to the provision. This was not a point that was touched on by the high-level committee. It was, in fact, go back 2 slides. You'll see that the provision made no reference to the individuals who'd be subject to it. And I actually think that's a very wise approach to take because much like the exceptions, it's hard to identify the classes of persons who will need to be in possession of information, confidential information relating to an arbitration. So here the obvious question arises, what do you do if information is given to a parent if a parent of a party receives information? What do you do there? What do you do with expert witnesses, with witnesses who testify at a hearing, court reporters, people transcribing the proceedings? So what do you do with all of these categories? I could imagine a creative argument that this is not an exhaustive list. The provision doesn't say only these parties need to. So arguably the courts could say they have an inherent power to recognize confidentiality obligations on other categories of persons. So maybe this can still be captured by that. And but until such time, I guess there is going to be a degree of uncertainty as to who these obligations can extend to beyond the parties identified in the clause. And the third, and to my mind, arguably the most troubling part of the provision is the exceptions. As you might recall, the high-level committee had identified 3 exceptions, which referred to where circumstances where a party has a legal duty. This would have captured your SEBI disclosure type scenario where you need to protect a legal right. So for instance, if you need to disclose an award in another proceeding to demonstrate res judicata, for instance, that would be a case where you could use that. And the third is the one that you now see here, which is the enforcement and implementation of the award. Now, I think it's quite apparent on its face why such a narrowly circumscribed set of exceptions, or rather just one exception, is problematic. Even if you're just thinking about it from the perspective of the proceedings itself, you have a plethora of court-related arbitration proceedings that you might have to take during the course of a proceeding, whether it's seeking interim relief, whether it's determining the arbitrator's mandate, whether it's to challenge an arbitrator. On the face of it, it would suggest you can't disclose documents relating to an arbitration for any of these circumstances as well. Can you disclose documents to third-party funders? Can you disclose them to experts? Still not clear. And I guess the third category is, if there is a public interest need for information to be disclosed, would there be a way to get information out? This is a relatively new provision, but as I understand it, there has already been an application to the Department of Space to get information relating to the Antrix and Devas arbitration. And in the context of that application to the Central Information Commission, this provision has already been invoked as a basis to decline producing information under the RTI. So like I said, the idea behind this clause was to perhaps make life simpler. I'm not quite sure we've got in there, and unfortunately I think the judges had a fair bit of work ahead of them, unless this clause can be revisited and revised. Thank you.
Thank you, Ms. Darshini. That was a very interesting perspective. Yes, these issues will arise. Suppose someone wants to approach the court, then what happens? Say under 9, under 17, under 34, would the confidentiality clause still apply? Because we are an open court, and once proceedings are filed in the open court, then how will this clause work itself out? This will be an interesting issue. In fact, I think the best law with regard to confidentiality comes from Australia, because there it's on a case-to-case basis, and you have to see what the facts are and how it is to be dealt with. That's very interesting. Now may I request Mr. Ganesh Chandru, who is now with Dua Associates, to make his presentation.
The Indian arbitration regime, as most of you know, how it was seen internationally prior to the 2015 amendments. I'll just give you an example. We were doing an international arbitration, and we had some barristers from England who were there, and one of them told me, when he knew I was a lawyer from India, this was a Singapore-seated arbitration. He said, in India, your cases go on forever. You have arbitrations, and then it goes in the court regime, and it goes on forever, and probably generations after generations they fight in court. I said, don't insult us like that. In India, we believe in rebirth. So it's not just generations, but even birth after birth we litigate. But when these amendments came, I did have an opportunity to meet him, and I said, have you seen our amendments? We need to make an award within a year with the tribunal being appointed, and now, of course, with the new amendments in 2019. This time limit is from the time the pleadings have been closed. When extensive amendments are made to arbitral legislation, there are bound to be glitches. So we have a fantastic legal system, the courts in India, which are there to look at this. And I think, in my view, the 2015 amendments have been an excellent one for India. But there have been certain issues with the 2019 amendments, and hopefully in due course that will be corrected through the court system as well. This, you know that these amendments were because the recommendations of the 246th the Law Commission's report, 246th report of the Law Commission. Mainly these amendments were made because of certain judgments of the courts. It's not that only India is unique to this. Everyone is talking about Singapore. In fact, my dear friend Stephen Lim once gave a talk, I think, at IPBA about how Singapore, also had problems initially with judgments and how the parliament had to correct it through legislative amendments. Each jurisdiction matures as it goes. And because of certain judgments of the courts, there was need for amendments to clarify, especially when it came to recourse against awards. And I think the 2015 amendments have addressed them very, very fairly. But the problem was because of the way the courts looked at the amendments, whether these amendments are going to be prospective in operation or retrospective, insofar as application to court are concerned. Generally, in India, we've had Supreme Court judgments starting from 1958 and then 73 and again in 1994. The Firestone Tire case and then the Hitendra Vishnu Thakur, essentially, which said, Supreme Court said, that if an amendment is procedural, then it would be retrospective. But if it's substantive, then it wouldn't be. It would just be prospective. So, therefore, if it was a procedural law, then it would have retrospective effect. What's the position generally in India? Section 26 is important. Let's look at this because now it's back because of the recent Supreme Court judgment. It said nothing contained in this act shall apply to arbitral proceedings commenced in accordance with the provision of Section 21 of the Principal Act. Section 21 is essentially the provision which says that once the notice of arbitration is sent to the respondent, the day the respondent receives it, the day the arbitration is set to commence. Before the commencement of this act, which is the Amendment Act, unless the parties agree otherwise, so that part is very clear. So for arbitrations, this amendments will apply only for those arbitrations that were commenced after 23rd October 2015, which was the commencement date of this amendment. But the problem came because the latter part, it said, but this act shall apply in relation to arbitration proceedings commenced on or after the date of commencement of this act. Essentially, what the problem was if the arbitration was commenced prior to the 23rd October, and court proceedings in relation to those were filed after 23rd October. So, what happens? Will you follow the old regime or the new regime? There was, a lot of High Court judgments which one said one way, the other said no, it's going to be retrospective. Finally, this matter was settled by the Supreme Court in the BCCI case. Before that, I'll just want to talk about Section 36 of the Act, because 36 of the Act talks about enforcement of awards, and that is important because these case laws, both the BCCI and the Kochi and Hindustan, arose in this context. 36 of the Act essentially provides for enforcement, and the section says that you can enforce an award as a decree of the court. And gone are the days under the 1940 Act when after the award you go to the court and get a decree in terms of the award and then you enforce. Now you directly enforce it like a court judgment. But prior to the 2015 amendment, both case law, the way it was interpreted, is once you file an application under Section 34 to set aside the award, then there would be an automatic stay of the enforcement proceedings. This was how they interpreted the law. And this was confirmed by the Supreme Court in FISA developers as well as in National Aluminium case, and it said that there would be an automatic stay. So this amendment itself to Section 36, which was the debate in these cases, was to facilitate enforcement of awards. So essentially the amendment said there would be no automatic stay if you, just by filing a Section 34 application, you need to file an application for stay, and while that application is being considered by the court can look at the Civil Procedure Code and probably order security or any other measures that they may want for the court to give you a stay. So therefore, it was not a blanket stay order that you will get on enforcement of the award. So this is a really very important amendment, as you would have seen from the users. Rohit spoke about how the industry, which is strapped with cash flow problems, this kind of stay is really kind of, completely bleeding them. So let's move to BCCI case, which exactly dealt with this issue. It put rest to the controversy. It said no. Insofar as the amended section 36 was concerned, it said that any application under 34, which filed after the commencement date, even though the arbitral proceedings was commenced before such date, the amendment would apply. So in other words, irrespective of when your arbitration was started, when you file a 36 for enforcement, you can, there's no stay to the execution of the award. The court in BCCI case clarified that the amendments to the Act would apply to court proceedings which have commenced in relation to arbitral proceedings on or after the commencement of the Amendment Act, which is 23rd October 2015. Therefore, even if the arbitration was commenced prior to the amendments, any court application after amendments came into force in relation to such arbitrations would be dealt with by the new provision based on the 2015 amendment. The court held that looking at practical aspects, this is very important. This was how the earlier case was decided by Supreme Court, then the court looked at it. The court held that looking at the practical aspects and nature of rights involved and the unfairness of the unamended provision, which granted an automatic state execution of award before the enforcement process of Section 34 is over, without having a look at the facts of each case, it is clear that Section 36 as amended should apply to Section 34 applications filed before the commencement of the Amendment Act. So this is what the court said. The court went a step further, and it also opined, at that time the bill was pending, the 2019 amendment was then the bill, and there was this 87. The court said, it opined that if the proposed 87 was enacted, the immediate effect of Section 87 would be to put all important amendments made by the Amendment Act on a back burner. Essentially, the court said that you will have a set of cases which will be dealt under the new regime. You will be having a set of those cases where the new act will not apply, but still it will be new applications, and you'll have two streams of case laws from court which will create chaos in the country. So that was the whole idea. In fact, the Supreme Court sent the judgment, copy of the judgment, both to the Law Ministry and to the AG's Attorney General's office as well, which you can see from the last paragraph of the judgment. But for whatever reason and wisdom, I think the legislators thought fit to have 87 into the 2019 amendments. Essentially, these are my last two slides, which it said that this 2015 amendment would not apply to arbitration commenced before the 2015 amendments, which was very clear. It would also not apply to court proceedings in relation to arbitration commenced before the amendment, irrespective of whether the court proceedings were commenced prior to or after the amendments. So essentially, therefore, the effect was it would apply only to arbitrations commenced after the amendments and the court proceedings arising from such arbitral proceedings. So this is fairly clear. So if you started your arbitration after the effective date, both for arbitration and court-related applications, only to those the new amendment will apply and not to the old regime. But then this essentially resurrected the old regime of automatic stay for those cases where they file applications under Section 34. So effectively the BCCI case was watered down by Section 87. Then came the Hindustan construction case, where the court clearly said that this was to be manifestly arbitrary, having been enacted unreasonably without adequately determining principle and contrary to public interest sought to be subserved by the Arbitration Act 96 and the 2015 amendment. The court also observed in paragraph 57 that deletion of Section 26 of the Amendment Act 2015, together with the insertion of 87 into the main Act of 1996 by the 2019 amendment, said categorically struck down as being manifestly arbitrary under Article 14 of the Constitution of India. I'll just go to this. The court clarified its own decision in BCCI and said it continues to be the correct position, and further that no automatic stay was available against enforcement of any awards. Further, the court also noted that an arbitral award, just because it's being challenged under Section 34, does not become unexecutable merely by virtue of such challenge being made. Essentially, the court even opined that pre-2015 amendment in his view, even in that regime, the court said that there was no automatic stay according to the court in the Hindustan construction judgment. Therefore, to that extent, the two judgments of the Supreme Court in visa developers as well as the National Aluminium were overruled in the Hindustan construction case. Essentially, now what this means, the debate as regards of applicability of the 2015 amendments has been laid to rest. I've put here in my slide for the moment in bold, because in India everything is only a comma and there's no full stop. So that's why lawyers are busy here, as the arbitration litigation lawyers. So hopefully there's no parliamentary interference again, and future case law, I don't know how this is going to happen. But in my view, this is a positive development for stakeholders and users, as you might have heard. In India, since it will be easier to enforce a award without apprehension of an automatic stay. Before finishing, I'll just point out to what Justice Manmohan said about use of alternate dispute resolution, because the courts are clogged. In fact, last week we had a conference where we were talking about ADR and how lawyers should play a very important role in encouraging ADR, especially we were talking in the context of mediation. Then they said, why is ADR not popular? Especially why are lawyers not supporting ADR? That's because ADR actually to lawyers means alarming decrease in revenue, not alternate dispute resolution. But I think that's not the case. I think even in cases where there is a settlement, as long as you help the parties, I think it's a very important duty upon the legal profession. I think that's what all these luminaries, including Mr. Nani Palkhivala, stood for the common man. He needs to get justice. Therefore, on that note, I thank you so much for this opportunity. Thank you.
Now may I request Mr. Stephen Lim to compare the Singapore law and the Indian law.
So I'll begin with a bit of clarification, which I have done, that there's no longer any power to modify or to make an award. And Justice Manmohan touched on a very interesting aspect of Sanyong engineering, which happens to be one of the cases I'll be dealing with today as well, whether the court can actually make an award. I'll go through the New York Convention and the model law, which is genesis. As you know, the New York Convention and the model law underpins the current system of international commercial arbitration. And this is where the power to set aside part of an award or refuse enforcement of part of an award is found. I'll go through that. And then I'm going to talk about how the trickier part, because that's the simple part of it, that it's clearly within the remit of the court. And in fact, we'd say it is the duty of the court to set aside only part of an award or refuse enforcement of part of an award if there's a part that actually should be upheld. That's the easy part, the concept of it. The difficult part is how do you discern between the parts that should be set aside, how do you separate the parts that should be set aside from the parts that should not be set aside. And I'll do that by reference to two cases. There's a case in Singapore, the Court of Appeal case of AKN and ALC, which had to deal with this problem. And then for the comparison with Indian law, I'm going to talk about the decision in Sanyong Engineering and NHI. So I've just put up here on the slide an obvious point, which is in today's system of arbitration, which is that the courts cannot interfere with the merits of the dispute, and therefore the court cannot modify or make an award. And there's a recent judgment of the Bombay High Court which stated this quite succinctly, stating that the court cannot correct an error in the arbitral award and cannot make an award under Section 34 of the Arbitration Act. And that's the regime that we are dealing with today. So moving on to this question of setting aside only part of an award or refusal of enforcement of part of an award, it's found embedded within the New York Convention. It's also within the modern law. In the New York Convention, it is found in Article 5.1c. Article 5.1 talks about the recognition and enforcement of awards and the circumstances in which they may be refused. And in 5.1c, it says we're dealing with a dispute not contemplated or not falling within the terms of the submission to arbitration. If that award contains decisions on matters beyond the scope of arbitration, that's the basis on which refusal of enforcement may be made. But it goes on to say, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, the part of the award which contains decisions on matters submitted to arbitration may be recognized and enforced. I've highlighted the word may, because I'll come back to that when I contrast this with what is stated in the model law, but it clearly states here that the court may separate the parts of the award which are enforceable and unenforceable, and the parts which are enforceable, which do not have any of the grounds that allow recognition, refusal of enforcement that apply, then those bits can be enforced. This is replicated in the model law in Article 34.2A3 of the model law, and the equivalent section is 34.2A4 of the Indian Arbitration Act. And it deals with a similar situation, dealing with a situation where there is a award contains decision on matters beyond the scope of the submission to arbitration. And it goes on to say, provided that if the decision on matters submitted to arbitration can be separated from those not so submitted, only that part of the award which contains decisions on matters not submitted to arbitration may be set aside. And I've highlighted the words only and may because there's a slight difference in wording here between Article 5.1c of the New York Convention and Article 34.2a of the model law. Article 5.1c is stated in permissive language. It says that the parts that do not fall outside the submission to jurisdiction may be recognized and enforced. But Article 34.2a of the model law says that only that part that does fall outside the submission to jurisdiction may be set aside. So that's in mandatory language, whereas Article 5.1c is in permissive language. The weight of commentary, though, says that the way Article 5.1c should properly be interpreted, it is that it is also mandatory, and that the pro-enforcement policy of the New York Convention requires courts to enforce parts of the award containing decisions on matters submitted to arbitration. So even though it's stated in Article 5.1c in permissive language, it should be mandatory, that there is an obligation on the court, just as there is in Article 34.2 of the model law, to enforce those parts of the award which do not fall foul of the grounds for either setting aside or refusal of enforcement. Before I leave this, the New York Convention on the model law, I should also say that even though it is not expressed in all the other grounds of Article 5 of the New York Convention or Article 34 of the model law, the pro-enforcement policy in the New York Convention and the model law requires enforcement of valid parts of the award under all grounds that are applicable in Article 5 or 34. So even on the grounds of arbitrability, public policy, or any of the other grounds on which there is a basis on which to say that only part of the award falls foul of the grounds that allow setting aside of refusal, then if there are parts that survive that, then the court should continue to enforce those parts. And that's captured within this pro-enforcement ethos of both the New York Convention and the model law. So that's the easy part, and that's the concept. The concept is that you can separate the award between what is enforceable and not enforceable, and you have to enforce the parts that are enforceable. The difficulty is that sometimes it's not so easy to discern what are the parts that are enforceable and what are the parts that are not enforceable. And I'll illustrate this by a decision of the High Court of Singapore, of the Court of Appeal in Singapore, in the case of AKN ALC. In that case, there was an application to set aside the award on grounds of breach of natural justice, which is allowed under Section 24B of the International Arbitration Act in Singapore, but it has its parallel in both the New York Convention and in the model law, in the ground that the party was unable to present its case. That's where its breach of natural justice is captured within the model law and in the New York Convention there as well. The allegation of breach of natural justice in this case is that the tribunal failed to consider all the issues put before it, and that it decided on points not argued by the parties. So the tribunal, when it issued its award, gave reasoning and gave a decision that captured points of argument that was not argued by the parties and which the tribunal did not put to the parties for submission. And the difficulty with this ground was that the court had to separate what I've termed disregard and misapprehension. And what is this difference? This difference is that there is a difference between a tribunal misunderstanding or disagreeing with the party's position. If a tribunal doesn't understand a party's position or doesn't accept the party's position and comes to what may seem at the end of the day a wrong decision on the merits, that's not a breach of natural justice. And as we go back to the beginning of the discussion when we talk about what is the foundation of modern international commercial arbitration, which is the court cannot interfere with the merits of the case. The parties have to accept whatever decision the tribunal ends up with, whether it's right or wrong. However, if the tribunal just completely failed to consider an argument, then that's a breach of natural justice, because breach of natural justice requires that the party have its opportunity to be heard. And if the tribunal doesn't consider at all what the party has said, that's a breach of natural justice. There's a typo in the last end of the slide where I flipped it. This distinction between disregard and misapprehension can be a very, very fine distinction. I put there some points taken from another Singapore case that was considered in AKN and ALC, where it said that there's often no clear, bright line separating a decision which was made without any attempt to understand the party's submissions, or, on the other hand, with a concentrated attempt which proved futile or ineffective, not because of a want or desire to understand on the part of the arbitrator. So, sorry if you get a bad arbitrator that doesn't get your point. That's nothing you can do that. But if you have the brightest arbitrator, but he just doesn't even attempt to understand your submissions, then that's a breach of natural justice. And in AKN and ALC as well, it was said that it's usually a matter of inference rather than an explicit indication that the arbitrator wholly missed one or more important pleaded issues. So it's a difficult area of analysis that the court needs to get into when such applications are made before the court, really, to try and get into the mind of the arbitrator. Did he consider the issue and just got it wrong, or did he just not consider the issue at all? The Court of Appeal laid down some guidelines. It's a difficult issue. They tried to lay down some guidelines as to how a court should approach a problem like this. I've listed 4 of them here. It said there's no breach of natural justice where the tribunal misunderstood the case presented and did not apply its mind to the actual case of the aggrieved party. That the tribunal has considered but ultimately does not understand the party's submissions, then this is the aggrieved party's cross to bear. It goes back to the point that the court cannot go and review the merits. And even if the tribunal makes a serious error of law or fact, the court cannot rectify this. The substantive merits of the case do not fall within or fall under the ambit of the court's jurisdiction on a setting-aside application. If the tribunal considered all the evidence and the submissions before it, any mistake as to the meaning or purport of the evidence and submissions, no matter how serious, will not constitute breach of natural justice. The court also clarified that there's no breach of natural justice where the tribunal did not mention the arguments raised by the aggrieved party. So you just cannot assume that if it was not mentioned in the award, then that is tantamount to breach of natural justice. The court said silence itself cannot be evidence that the tribunal failed to consider the aggrieved party's case. And the final point is that even if the tribunal did not engage with the merits of part of the aggrieved party's case in an award, this does not give rise to the automatic inference that it had overlooked that portion of the aggrieved party's case. The tribunal often deals with highly complex cases and can only include the most pertinent information about the award. So this is dealing with a situation that ultimately what you have before the court is the award. You may sometimes get the record of the arbitration, the transfers of arguments, be submitted by the parties as well, but it is from all of this that the court needs to discern whether the tribunal had actually engaged with the issues. And sometimes it is not an easy task at all. It's, to some extent, trying to look into the mind of the arbitrator. But let's look at the decision of the Court of Appeal in this particular case. What had happened is that the High Court had set aside the entire award. When you read the High Court judgment in that case, it looked as if the court was going through what was in fact an appeal process, going through all the arguments made in the arbitration and trying to see whether the tribunal had got it right or wrong. I think the court, to some extent, in that because it was trying to look to see, trying to walk this fine line between disregard and misapprehension, but in the end the court decided they would set aside the whole award. The Court of Appeal reversed the High Court and only set aside part of the award. And these were the two parts which they set aside. The tribunal had informed the parties on the last day of the arbitration that it would determine the quantum of damages based on a loss of chance claim. But what the claim made in the arbitration was actually for actual lost profits. So the tribunal had recharacterized it as a loss of opportunity to earn profits, and the parties were not invited to address the tribunal on that point. That's critical. The tribunal did not ask the parties to address them on that point, and then the tribunal unilaterally concluded that the loss of chance was to be quantified at 55%. So there was no submission on this, and this is what the tribunal came up with. The aggrieved party submitted they had not been given ample notice of the loss of chance claim, and the Court of Appeal agreed that in this case, on the facts, there was a breach of natural justice. The other point at which the Court of Appeal found that there was a breach of natural justice was that the tribunal had failed to consider one of the parties' arguments in relation to a particular claim. In this case, the tribunal had determined that the secured creditors of one of the parties to the arbitration had until the 15th of October 2012 to fulfill their obligation under one of the agreements. But then the tribunal was mistaken that the secured creditor had conceded that they would not be able to fulfill the obligation by a deadline, and held in its award, which was issued before the deadline, that the secured creditor had breached the agreement based on that concession. In fact, the secured creditor had not conceded this, and one of the key arguments that they had made was that the obligation had not even fallen due in the first place, and therefore making the deadline otiose. So because of the tribunal's mistaken assumption that they had conceded this point, the tribunal then did not engage at all with their argument that the claim was made prematurely and the obligation had not even fallen due. So the Court of Appeal found that this was also a breach of natural justice. You can see that these were very fine arguments that being made and required a careful study of the record, and in fact try to look into the arbitrators' minds to see whether or not they had engaged with the issues. So to sum up on this point and dealing with these issues of allegations of breach of natural justice, there's no bright line separating what is called disregard of misapprehension. And between the two, what you find is that there's a continuum that merges and blurs where disregard ends and misapprehension begins. I think that second example of the tribunal mistaking that the concession is an example of that. It's not so clear when you go through the issue. What if the tribunal instead had not made that mistaken assumption, but still made that finding? The court had to really look carefully through the record to see in fact what had happened. The court ultimately, I think, has to be aware that what it ultimately be engaged in is in a search, ex post facto, for evidence of a state of mind. Did the tribunal actually engage in that issue? What is their state of mind at the time? So how should the court approach this exercise? The answer may actually lie in judicial restraint, as stated by Chief Justice Suresh Menon, who gave the judgment in AK and AKC, that the court should only act where the breach of natural justice is shown to be clear and virtually inescapable. So where the line is not so clear and it's blurred, the court maybe should not act, but only act where it's clear and virtually inescapable. And the court must resist the temptation to correct an error of fact and law on the part of the tribunal as a failure to exercise its mind and therefore a breach of natural justice. However egregious that error may be, so it could be a perverse award. We've heard Justice Indu Mohoto talk about perversity in the Indian context. It could be a perverse award, but if there had been an exercise in the mind of the tribunal that simply got it wrong, then the court cannot interfere with that. And where a party had alleged that the tribunal had overlooked an argument altogether such that it would amount to a breach of natural justice, and it was equally plausible that the tribunal had simply misunderstood a party's argument, then the court in AKN and ALC refused to draw the inference that the tribunal had overlooked the argument in that case. So, right, you recall I said the High Court had set aside the entire award, but the Court of Appeal went back and actually upheld parts of the awards, and where there was any doubt about the issue, the Court of Appeal then leaned in favor of upholding the award rather than setting aside the award. So where the difference between disregard and misapprehension is fine, and it appears equally likely that the tribunal made an error of fact in law such that it overlooked a material issue, the court should not set aside the award, and judicial respect for the award must take precedence over concerns for natural justice in such cases. So that's the Singapore approach to this issue. I'll now turn to the Indian approach, and actually, I'm not an Indian lawyer, and when I was given this topic, I asked a friend in India, I'm dealing with this, can you send me a case that, Indian case that deals with this? And he sent me Sanyong, and I didn't realize how topical this case was. Everyone has been talking about this case, and Justice Manmohan has also mentioned this case, so well, perhaps I was given the right case. So I think you probably are then fairly familiar with the facts in Sanyong, and I may not want to go too much into the facts in Sanyong, basically concerning a construction dispute. Sanyong was the contractor. The contract provided that there was going to be price escalation for certain components. They were using a certain index. In the course of the construction project, the index changed. Of the ministry that was publishing that index stopped publishing the old series and published a new series. And Sanyong began to use the new series, but the NHAI published a circular requiring that a linking factor connecting the old and new series be used. This was the dispute. It went to arbitration. The majority award applied guidelines of the Ministry of Commerce and Industry establishing a linking factor between the old and new series. And the majority found that the guidelines were available on a certain website, but this was not part of the record of the arbitration, and the tribunal did not ask the parties to submit on this. So that was the ground for challenge. There was a dissenting opinion which agreed with Sanyong that the linking factor was not applicable because it fell outside of the contract, and later on we'll see the judgment of the Supreme Court, Justice Nariman had said that you can't make a contract for the parties. So there were three grounds on which the application was made to set aside the award. There was a section 34.2A3 that the party was not able to present its case. Section 34.2A4 that it fell outside the submission of scope of arbitration, and section 34.2B2 that it was contrary to the public policy of Singapore against the fundamental principles of Indian law. Justice Nariman wrote an extremely learned judgment. He went through an extensive survey of Indian law and international case law on all of the issues that were dealt with. He began to talk about the ethos of section 34.2A, and he said that this does not envisage a challenge to one of the merits. He cited the Saga, went through the whole history of Indian cases and where it is today, just as Justice Malhotra had mentioned in her opening speech today. And he went through each of the cases carefully, each of the grounds carefully, going through international authority as well. And in fact, I won't take too much time to go through all of this, because in effect what Justice Nariman has said that after going through all of the international cases, yet this also represents the law in India today. So he dealt with inability to present one's case, he dealt with cases outside the submission to arbitration, citing extensive international authority as well and agreeing with all of it. And also he dealt with section 34.2a of what falls within the ground of being falling outside of submission to arbitration. Again, citing extensive international authority and agreeing with it, including also section 34.2b on the ground of contrary, as well as contrary to public policy. So what's interesting then is we come to the decision of the court. On the three grounds, this is what the court found, that on the ground of breach of natural justice and not being able to present its case, the court found that the majority based its decision on material not before the parties, and Sanyong was not able, therefore, to present its case. This was a breach of natural justice, and the majority award should be set aside on this ground. And looking at this from an international perspective, I agree, and this wholeheartedly accords with what the Court of Appeal would have done in AKN and ALC. That if the tribunal did not give the party an opportunity to submit on its case and hear its case, that is a breach of natural justice. The Supreme Court did not allow or find any breach of the ground that was outside the submission to arbitration. And then the interesting part then is the Supreme Court's finding in section 34.2b is contrary to public policy. That's what the court found is that the majority award made a contract for the parties, and that this was against the fundamental principle of Indian law and is against public policy, and therefore the majority award should also be set aside. Now, I wholeheartedly agree with what the court found on breach of natural justice on being unable to present its case, and actually the court could have left it at that because there was enough to set aside to the majority award, but the court went on to talk about the breach of public policy point. And this is where, just looking at this from the international perspective, I wonder whether the court had set the bar too low for breach of public policy, whether this was indeed a situation where this was against the fundamental principles of Indian law, whether this was veering into the courts actually dealing with the merits of the dispute. The final point I want to comment on, which is quite interesting, was something that Justice Manmohan had picked out as well, was that what the court did after setting aside the majority award is that it exercised, as Justice Manmohan said, Article 142 of the Indian Constitution to do justice. It said that if the award is set aside, the parties would have to go back and restart the whole case, and there would be a great waste of time and cost. And therefore, since there was a dissenting opinion which upheld Sanyong's rights, the court was then going to order that this opinion really be enforced. And the question then is really whether, is this making the court making an award? Under the model law, Article 29 of the model law, which is also in place in India, the Indian Arbitration and Conciliation Act, all it says is that the arbitral tribunal, an arbitral tribunal with more than one arbitrator, any decision of the arbitral tribunal shall be made otherwise agreed by a majority of its members. So effectively, there is only one award, and it is a majority award. And a dissenting opinion is not an award, and I've also put down there authority from Gary Bond from his book on international commercial arbitration, saying that a dissenting opinion is not part of an award, nor is it another independent award. It is merely a separate statement from the dissenting arbitrator without any legal consequence on the award. So in this case, where the Supreme Court had actually, in effect, lifted up the dissenting opinion and made it an award, is that the court making an award, and how this is accord with the scheme of the Indian Arbitration Act, which follows the scheme of the model law. I end with those thoughts, and I'm sure there'll be many others who will have views on this. Thank you very much.
Download Tarang online radio app from Google Play Store.
You are listening to Tarang Devotional Online Radio.